before they can file a petition, or that the respondent appears to be sexually exploited, but only if the person consents to the filing of the petition.
Right. Okay.
All right.
Okay.
733. Who may originate a proceeding under Article 7? And there's 6 of them, so see how many you could name.
A peace officer or police officer, a person who was the victim of something that they did.
You need 3 more.
Oh, the presentment agency, if they're going from a JD.
Yes. 2 more.
Fuck.
All right, I'm going to give you a hint. I'm going to give you a hint.
Okay. A witness?
And the last one you're never going to get, because I forget this one too. Recognized agents of any duly authorized agency, society, association, or institution. So the total of the way that it reads is it's police officer, peace officer, the complainant, the witness, the recognized agents, or the presentment agency. It doesn't actually say parents, but like the parents could be the witness or the person or whatever that saw the, you know.
Right, they could be the complainant, obviously.
Yes. So, 737. Service of a summons and petition shall be made by delivery of a true copy thereof to the person summoned at least 24 hours before the time stated for appearance. If requested by a person acting on behalf of the respondent or by a parent or PLR, the court shall not proceed with the hearing or proceeding earlier than blank after such service.
Can you read that again?
Sure. Service, this is 737. Service of the summons and petition shall be made at least 24 hours before the appearance. If requested by someone acting on behalf of the respondent or by a parent or PLR, the court shall not proceed with the hearing or proceeding earlier than blank after such service.
Is it 3 days?
So again, if requested by one acting on behalf of the respondent or by a parent or PLR, the court shall not proceed with the hearing or proceeding earlier than
3 days.
After such service, and that is 3 calendar days. If, after reasonable effort, personal service is not made, the court may, at any stage in the proceedings, make an order providing for substitute service in the manner provided for substituted service in civil. True or false?
Oh, fuck. I didn't know you were on another question. Sorry.
Okay, so it's true. After reasonable effort, personal service is not made, the court may, at any stage in the proceedings, order substitute service in the manner provided for substitute service in civil.
Oh, yes.
Okay. What is next? Oh, this is an interesting one that we literally just went over today, and I didn't know about it. So everybody knows that a certificate of warrant expires 90 days, right?
Yeah.
This is talking about, in Article 7, the warrant itself expires in how long?
Oh, shit. The warrant itself? Does it not expire?
No, it does. It expires in 6 months.
Oh, fuck. I was going to say 6 months if you said no.
And can be renewed for another 6 months. Unless the respondent waives a determination that probable cause exists to believe that he is a PINS, no detention under Article 7 may last more than blank.
No detention may last for more than 3 days unless the court finds that such probable cause exists under criminal standards, blah, 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 or unless special circumstances exist warranting the extension for an additional 3 days, exclusive of Saturday, Sunday, and public holidays.
Okay, so which one is the one where it's Saturday, Sunday, and holidays?
If they want an extension.
So the initial thing is 3 days, and then the next one is 3 business days.
Yes.
Okay, so then the next question I have is 747. In an Article 7, a fact-finding hearing shall commence not more than blank after the filing of the petition if respondent is in detention.
Oh, shit. You would think, like, I haven't even looked at this shit. Oh, my God. Is this 3 days again?
Yes.
Okay, there's, like, a lot of 3 days.
I know. I guess in Article 7, if I'm not sure, I'm going to guess 3 days. All right, so let me read that in the, like, as if it was a sentence. In Article 7, PIN's fact-finding hearing shall commence not more than 3 days after the filing of a petition if respondent is in detention. Okay. Do you have that in your notes, too, in 747?
I have, if they're in detention, the fact-finding hearing shall commence not more than 3 days after the filing of a petition.
Okay. Then the next one says, this is also 747, if the respondent is in detention, the court may adjourn the fact-finding hearing on its own motion or motion of petitioner for good cause shown for not more than blank.
3 days. A lot of 3 days. I remember, like, a lot of 3 days.
What is it with 3 days? Okay, so then on motion on behalf of the respondent or the parent or PLR for good cause shown, the adjournment may be for...
oh my God. It's like a, what the fuck? I can't get the words out. Like a reasonable time or something?
Yes.
Oh my God.
A reasonable period of time. Then it says, successive motions, so I guess you're going to make a motion, to adjourn a fact-finding hearing may only be granted under special circumstances. Now, to me, I don't know what that means. Does that mean the calendar's full? So, like, I'm going to just say, no, you can't have Tuesday. I don't care if it's 3 days. I don't understand.
I'm going to be out. It's the summer. I'm taking my boat out, so.
Yeah, like, what does this mean? All right. The court shall state on the record the reason for any adjournment of the fact-finding hearing. So just a note that I have here. So the adjournment in the juvenile delinquency, it's 10 days if it's court or petitioner. In this one, it's 3 days.
Okay.
If it's respondent in juvenile delinquency, it's 30 days. And this one, it's a reasonable period of time.
Okay, I thought it was 20 days in JJ. So
and then the court shall state on the record, I'm going to try to get myself holding a microphone here. On the record, any reason for any adjournment of the fact-finding hearing. There we go. Oh my God. Okay. Next, the foster parent or any pre-adoptive parent providing care to the respondent shall be provided with notice of any permanency hearing, and the person shall have the right to be heard, but shall not be a blank.
Shall not be a complainant?
A party.
A party, okay.
So this is the foster parent or any pre-adoptive parent or relative providing care to the respondent shall be provided with notice of the permanency hearing, but they are not a party. They have the right to be heard, but not a party. And that's in 741A. Do you have a note there about it?
If there's, at the initial appearance, the respondent parent shall be advised, 741A. The foster parent or any pre-adoptive parent or relative providing care for the respondent shall be provided with notice of any permanency hearing held by the social services official. That's all I have.
Okay, so they have the right to be heard, but they're not a party.
Okay.
Okay. Before accepting, now this is 743. Now this is talking about an admission. Before accepting an admission, the court shall advise the respondent of his right to a blank. To a fact-finding hearing, yeah.
Okay, fact-finding hearing. Fact-finding hearing.
Okay, now it says, the court shall also ascertain through allocution of the respondent and his parent or PLR that the respondent And then he had to do these three things. 1, committed the act to which the admission is being entered. 2, is voluntarily waiving his right to a fact-finding hearing. And 3, is aware of the possible specific dispositional orders. And then it says, the provisions of this subdivision shall not be waived. So now, in criminal court, how many times do you hear them say, they waive the reading, they waive all this, everything.
Yeah.
In this one, they shall not waive it.
So they have to hear everything, even if they have an attorney.
Yeah. And then it says, upon acceptance of admission, the court shall state the reasons for its determination, shall enter a fact-finding order. The court shall then schedule a blank.
Dispositional hearing?
Yes.
Oh my god.
All right, now these just keep getting really hard, so can we do some of your easy ones?
Yeah, so we don't feel so stupid.
Yeah, because I'm going to feel really stupid when we do these.
So I don't feel so stupid?
I feel really stupid because I did most of these earlier today, and I don't remember them.
Okay. Where were we on? Okay. Oh, hold on. Okay. Notice of motion, including the court's own motion, for a new hearing or to stay, modify, set aside, or vacate an order must be served at least blank days before the return of the motion.
7 days?
Yes. Wait, let me just make sure. Yeah, 7 days.
7
Okay,
days. Now, can you just tell me again what this motion is for? Because this question was actually on my one test.
A motion for a new hearing or to stay, modify, set aside, or vacate an order must be served at least 7 days before the return date of the motion, and an answer must be served at least 2 days before the date of the motion.
So this is a motion in pins for a new fact-finding?
It's let me see, 761. It says as per 761. Hold on. Fact-finding or dispositional hearing, both.
Both, okay. So this one is 7 days. 7 and 2 for new fact-finding or dispositional hearing. Okay.
Yes. For pins is
0 to 17.
yes. Choose the best answer. For a person to be found to be a pins, he must be found to need A, supervision or confinement, B, treatment or confinement, C, confinement, D, supervision or treatment.
D.
Yes. At a pins dispositional hearing, the standard of proof is
Preponderance.
yes. Choose the best answer. At a pins dispositional hearing, evidence must be
Material and relevant.
mm-hmm. A pins proceeding is originated
By the filing of a petition
oh, I'm sorry. Where is a pins proceeding originated?
where the acts allegedly occurred.
Yes. A pins blank must be served at least 24 hours before the time stated to appear.
Summons and petition?
Yes. Which of the following choices listed lists at least one party who cannot originate a pins proceeding? A, witness, duly authorized agency, police officer. B, presentment agency wishing to substitute a pins for a JD. A victim of a pins. C, parent or friend. D, peace officer acting pursuant to special duties.
I'm going to go with C.
Yes, with the one with the friends.
Yeah.
Yeah, see, I got that wrong because it says at least one party. I didn't know what it was. I'm like, everything's right. Yeah. Okay. On its own motion, the court may substitute a blank petition under Article 10 for a petition to determine whether a person is in need of supervision.
Neglect.
Yes. The court must issue a warrant in an FCA Article 7 proceeding if
Must?
yes.
I don't
Do you know-
do they ever have to must?
Yeah, I don't know.
Oh, okay, so then I know the list, but I didn't know it was a must. It's when the
I don't-
summons can't be served, the person refused to obey the summons, the person's going to leave the jurisdiction, or
Yeah.
the respondent on bail or parole has failed to appear, or the summons would be ineffectual.
Yeah.
But I can't believe that's a must. I didn't know that that's a must.
Oh, no, it's not. It said it should read the court may.
Oh my God, I was going to say, what the fuck?
I know, I was going to say too, like, I never heard a must.
Yeah. But is that the list correct? Those 5?
Yep. Yeah.
No, yeah, because I think that list is like, it seems to repeat itself over and over again.
Yeah, it is. It's the same thing.
Same thing. The only one that's different is in Article 8, it says the petitioner's safety is in danger or something.
Oh, yeah, because it's like the order protection
Yeah.
shit. Yeah. All right, this is the last one I have. PIN's police records shall be kept in files separate and apart from the arrest of adults and shall be withheld from public inspection. For good cause shown and upon a written court order, they shall be open for inspection to 1. A parent, 2. A guardian, 3. Next friends, 4. Attorney of the PINs.
I think is all of them.
I don't know. 17.
This is probably important too because it's sealing.
Yeah, all of them. All of them.
All right, so read it again as if it's like a statement.
Okay. PIN's police records shall be kept in files separate and apart from the arrest of adults and shall be withheld from public inspection for good cause shown and upon a written court order. They shall be open for inspection to a parent, a guardian, a next friend, and the attorney of the PINs.
Okay.
And that's all I got.
Okay. Oh, that's it? Oh, so we gotta go back to the hard test?
Yeah, the shit one. Oh my god.
Damn it. Damn it.
Oh, I might have some other questions on my other test, so let me see.
All right, well, let's do a couple of hard ones and then we'll go back to that.
Yeah.
All right, here we go. After a finding, the court shall enter an order of disposition, discharging the respondent with a warning, suspending judgment for a period of blank.
1 year?
Yep.
Okay.
Continuing the proceeding and placing the respondent for blank.
Placing the respondent?
Yep. And I don't know this answer. Oh, wait, no, I do. Okay, I do. So the
6
placement.
months? Is it 6 months or something?
12 months.
Oh, 12 months. Okay.
However, the court shall not place the respondent where the respondent is blank years of age or older unless there's special circumstances.
Is it, I'm gonna guess, 10 or 14?
16.
Oh, fuck, 16.
At least we're back to the hard test.
Oh my gosh. Alright, so can you say that again?
Yeah, it's the court can't place the respondent when he's 16 or older unless there's special circumstances, and the court states these special circumstances in the order. Okay, so the probation period in Article 7 shall not exceed blank.
Oh shit, I just read this. Is it 1 year?
Yes.
Okay.
And in
1 year.
juvenile delinquency, it's
2 years.
yep.
Okay.
In cases,
And in criminal misdemeanor, it's 3 years.
yeah. In misdemeanor, it's 2 or 3 years for an A misdemeanor. For a B misdemeanor, it's 1 year.
And then for felony, it's 5.
3, 4, or 5.
3, 4, 5. Okay.
Yeah. Okay, so this says in cases of involving infants over blank and less than blank, the court may recommend restitution not to exceed blank.
Is it over 10 and less than 18 or something like that? Over 10 and less than...
16?
Well, this says 16.
I think
Well-
that's right.
Okay. 7:58. Oh my god, I'm messed up now with all the freaking 17-year-old shit now. It's less than 16, yeah. Okay.
And adjournment in contemplation of dismissal in a PINS is a period not to exceed blank.
6 months.
Yep. Who can make the motion for an ACD?
The PINS, the court, and the DA? Or whatever. Whatever.
It says either party or the court.
Whatever. You know what I mean.
I know what you mean. It's just funny. The ACD can include an education reform program if the acts involved blank or blank.
What? A fucking what? An educational what?
Reform program. And when I tell you the answer, you're gonna be like, what the fuck? This is brand new too. It's from 2018.
If they like stopped going to school or some shit, if they were smoking weed in school. Wait a minute. Okay, say that again.
It's cyberbullying or sexting.
They can get an educational reform shit,
Yeah.
so they can learn how to bully and sexually assault kids and sex.
No, it's to tell them not to do it anymore, I guess.
It's like when we get the sexual harassment.
Which
like,
I need to go for that again, I'm telling you, because I don't fucking know what it even means.
What?
I don't understand. I don't understand what it is.
Sexual harassment?
No, I don't. I've been to different trainings, and in one, it made sense. It was like, and then the other one was like, how is that sexual harassment?
All right, well, if you grab somebody's...
No.
If you grab a guy's dick on a train, you're not only a pervert, you're sexually harassing them if it's done at work.
Oh my god.
Oh my god.
Okay, next.
I really wanted to ask some guys that at work. I think I'm going to do that on Monday.
Don't, that would be sexual harassment.
Hey, do you think that...
But you have to freeze it like you can't be like if I did it. Because they'll be like, oh, Dorothy, you know, she's pretty cute. I would like that. It has to be like some random doing it.
Oh my god.
Pick like the most, like, I don't know. Oh my god. Okay, next. If the court requires restitution for the public good, the court shall require an agency or person to supervise the restitution or services. And the agency or person must report to the court not less frequently than every blank unless the order provides otherwise.
Oh shit. Is it like 3 or 4 or 6 months?
I think it's 6 months. For some reason, the number 6 months is sticking out in my head. And this is in 754.
My first reaction was 6 months, but then I'm thinking about something with 3 months. But
There is something with 3 months. I don't know what it is, though.
But I think it's like totally different article.
All right. Do you have 754 in your notes?
754. Yeah. Okay.
Says the court requires the restitution or services for the public good as a condition of probation or suspended judgment. It shall provide that the agency or person supervise the restitution or services, and that such agency or person report to the court not less frequently than every blank unless the order provides otherwise.
Where is this? 754?
Yeah, really think it's 6 months, but I don't know.
I don't even see this in 754.
Okay. I'm going to stop recording and check the app then. The answer is 6 months.